Mr. Majority Floor Leader.
Thank you, Mr. Chairman. We are in recess in the committee of the whole, so I'm going to give you the new and updated list. We're back in business here. If you guys want to write these down, the current list as we move forward. House Bill 47, House Bill 62. I'll give you a little few seconds here. I remember as freshmen, it was always awful to try to write quick. I'll give you a second. House Bill 47 is first, election equipment federal certification. House Bill 62 is next, open banking. Next will be House Bill 12, presumptive child support amounts updated tables. House Bill 55, election ballot order and party affiliation. House Bill 69, coal-fired facility closures, litigation funding amendments. House Bill 73 is annexation vote requirement, and House Bill 18, the next on the line, missing person alert systems for the committee of the whole. Thank you, Mr. Chairman.
The first bill for our consideration is House Bill 47, Election Equipment Federal Certification. The reading clerk will read the bill.
House Bill 47, sponsored by corporations, election equipment, federal certification, an act relating to elections. Mr. Speaker, your committee number 7, corporations, elections, and political subdivisions, to whom is referred House Bill 47, election equipment, federal certification. Respectfully report, same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Chadwick, Harrelson, Harshman, Knapp, Newsom, Olson, Ottman, Wiley, Yin. Representative Olson, Chairman.
You have heard the reading of the bill. What is your pleasure, Chairman Olson?
Thank you, Mr. Chairman. My pleasure is that I would like to move when the committee of the whole rises to report that it do so with the recommendation that House Bill 47 do pass. I further move the adoption of the standing committee amendment, and I'll go ahead and take up the amendment now. This bill is a codification of rules of the Secretary of State's office as it deals with certification of electronic voting machines. The amendment, while it looks substantial, it's very simple. That when we moved the rules into statute, we left some of the rules out. And so this amendment was brought to us by the office that oversees your elections and said, hey, if we're going to codify it, let's codify everything. So that's all this amendment does, is bring into the bill the remainder of the rules. And I'd ask for your favorable consideration of the standing committee amendment. Thank you, Mr. Chairman.
Any further discussion on the amendment? Representative Forrest?
No, he's waiting for the bill.
Okay. Representative Yin?
Mr. Chairman, thank you. I don't think I'll do this right now, so I would ask you to vote aye on the amendment. But there's one part, it's on line 33 and 34, and that kind of gives a broad authority to the Secretary of State to require by rule. So that part is actually a little bit redundant. There's a part C, so all of these subsections are of a part A. There's a part C that already grants the Secretary of State rulemaking authority in that situation. So I think second reading, I'll probably take something to take that out, but not pertinent to disapprove of it now.
Any further question having been called? All those in favor of standing committee amendment number 1, say aye. Opposed? No. Standing commitment amendment number 1 has passed. We are now back on the bill.
Yep, Mr. Chairman.
Chairman Olson.
Yeah, thank you. I'd like to turn over the explanation of House Bill 47 to one of our newest members and the representative of our newest district, House District 62.
Representative Forrest. Chadwick.
Thank you, Mr. Chairman. As our chairman indicated, this is an act that simply codifies what's already being done in the Secretary of State's office. On voting machines, it's very simple. Nothing complicated about it. There's a lot of text, but yeah, this is what they've already been doing. This simply codifies that. So I would urge your passage of this bill. Thank you.
Is there any further discussion on the bill? Question being called. All those in favor of Chairman Olson's motion that when the committee of the whole rises to report, it does so at the recommendation that House Bill 47 do pass. All those in favor say aye. Aye. Opposed, no. The bill passes. We are now moving on to the next bill, House Bill 62. The reading clerk will read the bill.
House Bill 62, sponsored by Minerals, Open Banking, an act relating to banking. Mr. Speaker, your committee number 9, Minerals, Business and Economic Development, to whom is referred House Bill 62, Open Banking. Respectfully report, same back to the House with the recommendation that it do pass. Ayes, Representatives Banks, Burkhart, Conrad, Heiner, Knapp, Larson, Lawley, Tarver, Western. Representative Burkhart, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Burkhart?
Thank you, Mr. Chairman. I move that when the committee of the whole rise to report, it do so with recommendation that House Bill 62, Open Banking, do pass. There are no standing committee amendments, and I turn explanation of the bill over to the good representative from the north central part of the state.
Representative Western.
Thank you, Mr. Chairman. So I'm bringing you House Bill 62, which is open banking. And this came out of our Select Committee for Blockchain and Financial Technologies and Digital Innovations. And I know it kind of seems broad. You look at it, you might not have any idea what it's talking about. But first, before explaining the bill, I want to give the bill some context. Really, it comes out of the times that we're living in. And that is that in this digital age that we are in, where technology is constantly advancing. This is an example of a piece of legislation where our regulation needs to advance with it too. So what it does is it allows for banks to engage in practices that help kind of innovate their practices in serving their customers. So basically banks interact with these things called APIs, application program interfaces. And I know this may seem kind of some crazy jargon, but these APIs are used all the time by financial institutions all across the country, all across the world, to help make the services they do better, more user-friendly, more seamless, those kind of things. And that's exactly what this does. It allows some of these banks that have been established in Wyoming, these crypto banks, these special purpose depository institutions, it allows these banks to engage in these API, in some of these practices with some of these APIs. So they can come in and they will use customer data, for example, to help them with an app on their phone for budgeting. What they need to do is those APIs is they need to access those kind of customer data that the banks have. And so it just leads to a more innovative experience. So to be clear, this was not drafted in mind with a lot of our local banks that we all use, but this was drafted in mind specifically with some of these digital asset banks that we have passed, that we have set up right here in the state of Wyoming in recent years. So the bill creates definitions. I think one of the things that it's important to take into consideration here is on page 2, line 6, express written consent means a customer's affirmative written response to a clear and conspicuous notice regarding the collection, use, or disclosure of customer data for the purposes of open banking. And obviously, it defines open banking, and very importantly, it allows our banking division to promulgate rules around this. So to kind of frame it in some more context, do we absolutely have to have this bill? No. Can I guarantee you that this bill will create jobs in a certain amount of time? No. But if we go back to some of those digital asset banks that we set up, 5 years ago, we were having this exact conversation. We can't promise you that it will create jobs. We can't promise you that it'll have an impact, but we're pretty sure that it will. Fast forward 5 years, here we are, and we're in a position where there are about 200 or so jobs right here in the state of Wyoming that have been created. And that's because we put a stake in the sand and said, hey, we are innovative, we are open for business, And we want these innovators to come here and set up shop right here in Wyoming. And so this bill has that same type of philosophy. So I don't want to ramble on too much, but if there are any questions, I will be happy to answer them.
Any further discussion on the bill? Representative Allred.
Thank you, Mr. Chair. I have a written paper here, or a paper here from a banker who said that the Consumer Financial Protection Bureau, which is a federal agency, had not come out with rules for open banking until this bill came out of committee. And so since then, they have written those regulations, and it's their opinion that with the banking, Division of Banking, and with this, this would be redundant. It's just a duplication. And so I would urge a no vote. Thank you.
Representative Western. You have anything to say?
Mr. Chairman, it's okay. Let's go to the gentleman at the front of the room so I can take his question as well.
Representative Locke? Great.
Thank you, Mr. Chairman. Just a few questions in terms of the open banking. In us putting some legislation in place, is there wrapped around this somewhere? Is there any references to security, protection? It talks about access to customer data, that kind of thing. Obviously, there's a lot of security, confidential, and protective measures to be put in around that. I'd just be curious where that falls into this bill and where that falls into this process. Thank you, Mr. Chairman.
Representative Western.
Thank you, Mr. Chairman. A couple of good points. Yeah. The first speaker talked about the federal agency that regulates these types of things. And they made the point that, well, technically the federal regulations could come and because of the supremacy clause. And that is technically true. But I think, let's ask ourselves this. When have federal regulations got it just right? Not very often. Best case scenario is the agency that oversees these types of issues at the federal level comes up with perfect regulation, strikes the perfect balance, and there's true that would lend this type of legislation here in the state kind of unnecessary. But again, how often do the feds get it just right? The federal agency that regulates this stuff is using a legislation passed in DC that was passed 12 years ago, and they still don't have rules and regs out. Being Wyomingites, I like to think of us as folks who take initiative, who see these types of things coming around the curve, who pass the necessary regulation to, one, put a flag in the sand saying, hey, we're open for business, for this innovative type of business that is the future. And two, puts down that regulation saying, we're not going to wait on the feds to tell us what to do. We're going to take the initiative here and be proactive. So there's plenty of different, for example, there's the federal bureau that regulates this stuff. They are certainly considering some of those types of things, but in testimony from our banking commissioner, there's a whole host of things that they would consider as well while putting into rulemaking and regulation. Coverage of data providers who will be subject to the proposals under consideration, recipients of information, including customers and authorized third-party users, third-party obligations, records retention obligations. These are all things that our banking commission talked about in testimony that they will actively consider through the rulemaking process in the event that this does get passed. And of course, these banks, these APIs are all subject to the data privacy laws that are currently on the books, both at the state and federal level.
Representative Locke.
Thank you, Mr. Chairman. And thank you, by the way, for the explanation. And so I'm not necessarily one way or the other on this. I'm really truly just trying to learn on this one. Is there value in adding some additions to what we put here to ensure that security and customer privacy and confidentiality is secured? Or are there other very clear protections that we can ensure in place between this bill and that implementation?
Representative Western.
Thank you, Mr. Chairman. So the Division of Banking already has requirements in place for security for their banks. In addition, there's, can't use the actual names of the acts, but there's already federal regulation in place as well that already require banks when it comes to records retention, record security, encryption amount, that types of things, third-party vendors, what they can and cannot do with that data. So there's already quite a bit of regulation on the books already that protects them. This just simply says to the banking commissioner, to these APIs that want to come in and work with our local speedy banks, these local digital asset banks, we're going to promulgate the rules specifically around this type of practice.
Representative Yin.
Thank you, Mr. Chairman. Just to add on to that, so Title 13 in our green books are all of the provisions that oversee banks. So this is just an additional one. Everything that banks already have to do to secure private information is already in our statutes. And I think even Title 2 has to do with the organization, sorry, Title 13, Chapter 2. But all of it is that they're one of the most regulated industries in the country, so not just the state and the federal. This is just an enabling provision for them to do one more thing, but that security is already covered by many other statutes.
Any further discussion on the bill? Oh, Representative Stith, Speaker Pro Tem Stith.
Mr. Chairman, I just want to speak on and in support of House Bill 62. The language is permissive. It allows banks to do this. With respect to the federal government, it's very early in its stages of proposing any federal regulations on this topic. So what we do here, we can get out in front of the regulatory framework. So on and in support.
Any further discussion on the bill? Question being called. All those in favor of Chairman Burkhart's motion that when the Committee of the Whole rises to report, it does so with the recommendation that House Bill 62 do pass. All those in favor say aye. Aye. Opposed, no? No. House Bill 62 has passed the Committee of the Whole. The next bill for our consideration is House Bill 12. The reading clerk will read the bill.
House Bill 12, sponsored by Judiciary, presumptive child support amounts, updated tables, an act relating to child support. Mr. Speaker, your Committee Number 1 Judiciary, to whom is referred House Bill 12, presumptive child support amounts, updated tables, respectful report sent back to the House with the recommendation that it do pass. Ayes, Representatives Chestick, Crago, Haroldson, Oakley, Provenza, Rodriguez-Williams, Washit. Noes, Representatives Jennings, Nemec. Representative Washit, Chairman.
You have heard the reading of the bill. What is your pleasure, Chairman Washit?
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report, it do so with a recommendation that House Bill 12 do pass, and I will present the bill.
Please.
So before you members, you have House Bill 12, deals with the presumptive child support amounts listed out in table form. What this table is all about is when a court judge is determining how much child support a non-custodial parent needs to pay, they use the tables to find a presumptive level of compensation to the custodial parent. The court then will determine, based upon a myriad of other factors, moving that amount up or down. So this is the beginning point, if you will, as a court judge is determining how much child support will be paid. It starts with this table. The legislature required in statute that the agency in Wyoming that looks after Wyoming families, in some cases, update these tables every 4 years. Unfortunately, twice before, that agency has dutifully complied with our statute, hired a consultant, put together presumptive tables, and come before this legislature, and no action was taken. And so now we're about a decade out since the last time these tables were updated, And it is time for us to do our due diligence and comply with our own statutes, rather than simply asking our agency to spend money every 4 years to generate a report for us to ignore. So when you go through this bill, it's fairly lengthy, but what you'll see very quickly is that the tables take up the bulk of the bill. And those tables begin looking at a family unit that has one child, and then it looks at the net monthly income of both parents, the percentage of income allocated for one child, and the base support plus marginal percentage. And then it goes into situations where you might have 2 children, situation where you have 3 children, 4 children, 5 or more children. And so the department has hired a consultant who did all the legwork, and this is the best estimate of what these presumptive child support tables ought to be. So who benefits from us increasing these presumptive tables? Hopefully the children. The children who are being raised by the custodial parent have needs, and that's what child support is intended to address, the needs of the children. And so I ask you to support the bill. It's a committee interim bill. We've looked at it extensively over the interim, and it's, it is what it is, but it's time. It is past time for this body to pass these presumptive table increases. Thank you.
Representative Brown?
Thank you, Mr. Chairman. Just a question on this. And I may have missed it, so if I did, I apologize. Does this automatically adjust those types of child support payments that are already in place and that are already adjudicated and already working through the process? Does this affect those parents that have a set schedule and they've come to an agreement? Us adjusting these tables here today and passing this law, is it automatically just going to adjust those up? Thank you.
Chairman Washit?
Thank you, Mr. Chairman. It is my understanding that there's nothing automatic about this, that these are set by the court, and the child support arrangement that has been in place by the court will remain in place until it is changed by the court. Nothing automatic.
Representative Trujillo?
Mr. Chair, I'm here to ask for a no vote on this. Child support money, yes, is for the children, but if we're going to talk about for the children, we need to look at 50-50 custodial, what is it? Parenting, yes. For instance, let me see, I have some stuff written down here. Hold on. Okay, so what I wrote down is non-custodial parents have a disadvantage. The state takes child support, but child support does not implement custody. Therefore, the non-custodial parent is going to have to pay a filing fee, get a lawyer for themselves, then get a lawyer for their children to be represented. That's an undue burden because this doesn't do child custody. This just says you're a non-custodial parent, pay the custodial parent this much. Then we put their both incomes together. What if the custodial parent is on housing, welfare, and works a minimum wage job? That's a 50-50, but it's still going to go to the uncustodial parent, and I believe it's unfair to them. And I'm asking for a no vote.
Chairman Washit?
Thank you, Mr. Chairman. I appreciate the question. As I said, this is the beginning point. These presumptive tables are the beginning point in establishing what child support should be paid. And the court has a whole list of other things that the court will assess as it determines whether to move up or down on the presumptive table. There is, in fact, a provision for when we have a parent who is voluntarily unemployed or voluntarily underemployed, the court can take that into account as well. The court can look at things like overtime. If a parent regularly works overtime and has consistently worked overtime hours for a number of years, those overtime hours can be included in the assessment of what compensation needs to be paid for child support. But if the overtime is sporadic and infrequent, then it will not be included. So I'm just asking the body to have some confidence in your district court judges as they're setting child support. And just know that if we want to address child support in a broader context, this isn't the vehicle to do it in, right? Any one of you can bring another bill and we can reevaluate child support in Wyoming. But what this bill does is it takes us down the road to meet the requirements that has already been put in place in our statutes when it comes to child support payments. Thank you.
Representative Brown.
Thank you, Mr. Chairman. I think this is a really good discussion, and frankly, I think it's one that needs to be had, but I am a little, I don't know where I ultimately fall on this bill. This is going to be one of those that our good friend from Lander said that, you know, wait till third reading and figure out which way you're going to fall on this. But I guess I have a concern that we should do this just because it says so in the statute, because there's a lot of things that we write into statute and it says that we should update and we don't do. One of those being education. You know, we've done a lot of things where it says, hey, we should redo this, and we don't redo this and we don't look at it. My concern about going in and updating this is I just was, and it's kind of funny when you watch this floor, the amount of attorneys that jumped up and started huddling around each other to start talking about this was quite amusing. What I do look at this is us updating this does give me a little bit of cause for concern. And only for the fact that that parent who does have something in statute, or not, sorry, in statute, but in agreement, that if we amend this, there's the potential for modification. And I'm getting a head shaking no, so I'm excited to hear why not, but I feel like there would be a potential for modification based off of these new tables. And I feel like this is an opportunity for the non-custodial parent to be taken advantage of in the future. When we update these tables, we're setting the ground, right? We're setting the floor work. And so I'm interested to see the Good Country lawyers getting up and gonna give us a little bit more information. But as it stands right now, I'm a little concerned that we're gonna modify this up, and it really does open up the door for potential modifications. And our court system's already bogged down. I don't know that our judges wanna see more modifications flying through. So thank you, Mr. Chairman.
Representative Crago.
Thank you, Mr. Chairman. So the first thing you need to do is grab your green book and open it up to section 22304. And if you do that, you will see there's a set of tables in there. And in the tables are these numbers. And those are that's really all we're addressing today, is the economic part. You have to divide this child support discussion into two different topics: numbers and policy, okay? Today, we're just dealing with the numbers, just the tables. If at some other point we want to delve into, like the good chairman said, the policy of that, we can. But if we don't adjust these policies, what are economists that we have hired and paid money to do a job for us, if we don't listen to them, the people we're going to hurt are the custodial parents. That's what the point of the tables are, is try to fix that so that we're not undercompensating nor overcompensating. And if you look at, if right behind the tables, it starts talking about, which this legislature changed a few years ago, how we address that. And non-custodial parents are actually treated much more fairly today than they were 5-10 years ago. And so I would urge you, go look at the rest of the statute. But know today, all we're dealing with are the numbers. And we're just doing what the economists that we've hired to study this tell us to do. We're not addressing policy. We're not getting into that yet. Maybe some other time. Thank you, Mr. Chairman.
Representative Provenza.
Thank you, Mr. Chairman. And to add to the point that the Good Country lawyer stated, if you continue on through the green books and you look at 20-3-307, we're looking at presumptive child support to be followed, deviations by the court. So the court is not married to the number in the table. The court has to take into account things like age of the child, the cost of necessary child daycare, custody issues. There's a whole list of things that also need to be brought into consideration. So it's not just, here's the table, you're paying for it. It's a conversation with the court and the family as to what is the fair aspect of it. So making sure that we also realize that even into other statutes under this title and this chapter is critical in understanding kind of the process and procedure and then what folks end up actually paying. Thank you.
Chairman Washit.
Thank you, Mr. Chairman. Yesterday, we had a very worthwhile conversation that included some discussion about waste, fraud, and abuse in state government. And I would suggest to you that when we as a legislature put an obligation on our agencies to hire a consultant and do this work, and then we turn around and ignore the work, we're contributing to the waste. In fact, we caused it. We ask these agencies to do this and put these tables together. They do so at our behest. I think we have a duty to follow through. And again, I just say that we aren't, there's always a temptation when we pull up these bills on different topics to want to talk about the topic broadly. We really need to focus on the language in the statute that we're considering. And here, there's not much language. As the good country lawyer told us, it's just the numbers. And we're not setting the floor, okay? The court can go up, the court can go below the presumptive table. So we're not even setting the floor. We're just establishing a starting place for that discussion. Please vote aye.
Representative Brown.
Thank you, Mr. Chairman. I think I'll probably vote aye on this, but I want to be careful, especially in this body, especially for the new members, of utilizing the argument that, well, we've taxed ourselves and we've told an agency to go out, hire somebody to tell us what to do, and we're going to ignore it. I've only been here 7 years, and I can count 3 times that we've hired recalibration consultants for our education model at the cost of about $2.5 million a piece. And this body has unilaterally decided, absolutely not, we're not going to recalibrate. So if we're going to utilize the terms that, hey, we tell somebody to go out and go hire this, we've done it to ourselves and we still say no. So that argument doesn't hold a lot of water with me. What I do think, I appreciate what the good chairman just stated, is this is not the floor and we can't have those deviations. What my ultimate concern is, and it's a very honest and heartfelt concern, is once we adjust these numbers and things happen, do the attorneys get really excited, contact their constituents and their custodial parents and say, just so you're aware, the tables have been updated. You can ask for more money. You can get this adjusted. And we see this movement and we see these thousands of court filings across the state with an already bogged down court system. That's really where my heartburn comes from this, is modifications could become a huge influx on our court system that's already burdened just by us updating this. So I'll probably vote aye just to move this through and have this discussion. Again, I see that I've stirred the hornet's nest with another attorney up to take the, 2 attorneys coming on. So I'll stand back. Thank you, Mr. Chairman.
Representative Oakley.
Thank you, Mr. Chair. I'm actually not going to do the legalese, but I do want to address that because, believe it or not, I agree with the good representative from District 9 in the way that I don't think that this is about being mandated and, well, we did a study, so now we have to increase. The numbers have not significantly gone up. I was looking at these, trying to remember from doing this in law school 15 years ago, and I don't think it's gone up a lot from then. I think this is about inflationary pressures and fairness, as was said earlier, to the custodial parent. I think this is the right policy decision to do, and I think that's why it's mandated to look at, but I don't think that's why we do it. I think we do it because it's the right thing. It's time to update for these custodial parents. And to address something said earlier, again, custody is a different issue, and there are all sorts of different types of agreements made between parents. This is specifically about a non-custodial parent, what they should pay. So I would urge an aye vote for this bill because I think it's the right thing to do, not because it's what we have to do.
Representative Trujillo?
Raising this, I understand is in the Green Book and it's part of policy, but I come from a very poor district where I have a lot of uncustodial parents that are barely meeting their rent and their mortgage because most of their check is going to child support. If we raise this, you're raising the possibility of my constituents losing their homes. So I just ask you to think about that.
Representative Penn?
Thank you, Mr. Chairman. I guess I would just like to say that if the courts still have the leeway of looking at these numbers, these base numbers, and adjusting up or down, what is the point in raising the actual percentage? So in one of them, it goes for one child raising from 32.9% to 35%. So are we saying that in the last 8 years or however long it's been that we changed it, that one child costs 3% more? This isn't a flat rate, this is a percentage. And so for that reason, it seems in my mind that it should already take into account some of that inflationary change over a decade or 8 years time. So I guess that's just the question that I would raise is this necessary? We've already identified the fact that the courts still have the leniency to adjust up or down. And so I guess, in my opinion, we may just leave it and let them handle it because they're the ones that are dealing with the individual circumstances of each case. Thank you.
Representative Provenza?
Thank you, Mr. Chairman. I just want to go back to my good friend from House District 9 on the concern of having people kind of flood back and go to the court and have concerns about raising that child support. And maybe my good country lawyer friend over here can answer some of that. I think that's probably unlikely, but there's also the issue that maybe they actually need more. Maybe the child support isn't covering the costs. So what are we asking of parents that have custody that aren't getting enough help that could in paying for daycare, paying for childcare expenses, paying for healthcare expenses with their children? Remember, it took 2 people to have a child. Thank you, Mr. Chairman.
Speaker Pro Tem Stith.
Mr. Chairman, thank you. I think the 2 points, the representative from District 33 raised a great point that we really do need to think about. I think her point was that isn't inflation already baked into these tables? And if inflation is already baked in, then there's no need for change. I think that was a fair summary of what she said, I think. Notice, however, that at the top end, you'll see on these tables, at the top end, as the absolute dollars get higher, the percentage gets lower, okay? And as a result of that, as your absolute dollars are worth less and less over time, you do need to recalibrate it. In other words, if the percentage were the same for every income level, then inflation would be baked in and there would be no need to change the tables at all. But because, for example, I think the current table, the existing one at the very high end, for every dollar over, it's like 12,000 and something, that 5.9% is the amount that goes toward child support. And so imagine a situation of, say, hyperinflation, where inflation is 1,000%, right? Well, then the buying power would be not enough to buy the same goods and services that our children now need. So I think that's a conceptual response, right? That we can't leave these tables baked in, set in stone forever, because although inflation is partially baked in, it's not fully baked in because of the declining percentages at the high end. With respect to the point from the representative from District 9 about this will lead to a flood of child support modifications, the point there to remember is that it's probably true that child support for a given non-custodial parent will go up a little bit, right? Because we're adjusting it by about a percentage point or two, okay? So, but the way the law works right now is that just because your child support goes up by $15 or by 2% doesn't give you the right to go back for a modification. You've got to show, to get a modification, you've got to show a change in circumstances that results in a 20% difference from what you're already paying. And it's that 20% material change in circumstances that I think would prevent a huge flood of child support modification petitions. So I don't think we're going to have a clogging of the courts for that reason. On in support, thank you.
Question being called. All those in favor of Chairman Washat's motion that when the committee of the whole rises to report, it does so with the recommendation that House Bill 12 do pass. All those in favor say aye. Aye. Opposed, no. House Bill 12 has passed the committee of the whole. The next bill for our consideration.
Mr. Chair, privilege of the floor, if I may.
Representative Larson.
Thank you, Mr. Chairman. Members of the House, above me, directly above me, in a position that they could drool on us if they wanted to, we have Wyoming credit unions with their representatives representing 21 of our great credit unions in the state of Wyoming, which encompass 336,100 Wyoming members. Please welcome them. They're here every year, and thank them for our lunch today.
Okay, House Bill 12 has passed the committee of the whole. The next bill for our consideration is House Bill 55. The reading clerk will read the bill.
House Bill 55, sponsored by corporations, election ballot order and party affiliation, an act relating to elections. Mr. Speaker, your committee number 7, corporations, elections, and political subdivisions, to whom's referred House Bill 55, election ballot order and party affiliation, respectfully report same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Chadwick, Harshman, Olson, Ottman, Yin. Noes, Representatives Haroldson, Knapp, Wiley. Excused, Representative Newsom. Representative Olson, Chairman.
You have heard the reading of the bill. What is your pleasure, Chairman Olson?
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report it, do so with the recommendation that House Bill 55 do pass. I further move the adoption of the standing committee amendment. And I'll explain the standing committee amendment as I explain the bill, because this bill now does one thing with the standing committee amendment if you adopt it, and I'm going to urge that you definitely adopt it. Prior to the amendment, this bill does two things. Okay, number one, what this bill in its original form does is randomize the order of names on the general ballot. That's the first thing that it does. The second thing that it does is it allows for an independent candidate to put a party affiliation next to their name on the ballot. So it would read independent, majority party Republican, independent, majority party Democrat. I know we typically don't say those on the House floor, but they are within the bill. The amendment, what it does is narrow this bill down to one thing, and that's just order on the ballot. So it eliminates that concept that an independent candidate can place a party affiliation, Libertarian, Republican, Democrat, Green Party, whatever it may be, next to their name. So I'll take any questions on the standing committee amendment.
Question having been called, all those in favor of standing committee amendment number 1, say aye. Aye. Opposed, no. Standing Committee Amendment number 1 has adopted. We are back on the bill.
Thank you, Mr. Chairman. So now we're back to a much narrower bill that I hope that we can all rally behind and support, and that is simply that on a general ballot, there is complete randomization between if there's 2 candidates or 3 candidates, because there might be a minority party. However many candidates are, they're simply randomized. No matter which county you go into or which person walks in, it's a randomization of the names on the ballot. And that's really it.
Are you ready for the question? Question being called. All those in favor? Representative Haroldson.
Thank you, Mr. Chairman. I'm fast at running, but not that fast through the labyrinth. So I wanted to speak to this bill. The randomization of this, you know, how it currently stands is every county, all 23 counties, the primary party or the party that, as far as I know, votes into however they vote on the federal elections will dictate which party sits at the top for the elections. And I believe that is how it's been. It's a good standing way that we are doing it. And I believe that turning this is probably a miscue. I was a no vote in the committee, and I believe that the way we've done it is probably a wise way. The other thing you need to understand is this bill was brought on the floor 2 years ago, and it was defeated resoundingly. As this is definitely not the way that we have done it, nor I believe this is fixing really a problem. So I would urge a no vote on this.
Representative Yin.
Thank you, Mr. Chairman. So 2 things. The primary ballot's already randomized. It's rotated based on what precinct you are. They rotate the ballots. They rotate the order on the ballots. So on your primary ballot, this is already happening. This is happening. The bill here is specific for the general election ballot. In my county, my party is on the top of the ballot. What we heard in testimony was a study of data done on whether there is an effect on being the top name on the ballot. It was about a 3% effect from the study that we were given. The issue is, I want to make sure that I'm confident that I know my name's on the top of the ballot in my county. I want to be confident that I win on my merits, not because of my ballot order. And I think that's a good reason to vote aye on the bill.
Representative Wiley.
Yeah, I just wanted to talk to this and justify my vote of no on this. For one, I have full confidence in all the voters of Wyoming can read and the ballot is legible to them. And I understand why we should run on our merits and our value to be in these elected positions. But I also would I like not to fix something that's already working and not broken in the state. I believe that this is a non-issue, and I will vote no. Thank you.
Representative Haroldson.
Thank you, Mr. Chairman. So the randomization of the primary is an intelligent situation. We have 4 individuals running on a party ticket, and at that point, it's a randomization of those names. And then once obviously the primary is completed, those names get sent forward into the general. So that's apples and oranges. I don't think that's a comparison probably that really applies here. But in that primary sense, the randomization is a great thing. In the sense of the general, I believe that going with the standard is definitely our best option.
Representative Stiff.
Mr. Chairman, thank you. On and against House Bill 55. Our current system is not broken. Let's not try to have some fix to this. All of you work very hard. You've attended, you go to lots of meetings, you go to fundraisers, you fold up the folding chairs, you put up the picnic tables. You work really hard to meet with your constituents. All of that hard work that you've done to build up the party of your choice, in some sense, goes unrewarded if we adopt this bill. So on and against.
Representative Zwanitzer?
Thank you, Mr. Chairman. And as, again, the chairman of the interim committee, just to be fair to the process. So members on the interim corporations committee, of the 9 members in the House, we did have a libertarian and an independent and a Democrat. And so this was one of the interim topics that was brought to us, that the minor parties would like this to be randomized because they felt there is a 3% to 5% bump, depending on the county, right? We have 21 counties that the majority party of this body controls. In those county elections for the US rep, we have 2 counties that the Democrat has for US rep, which is how we base it, got more votes. And so in the issue of ballot fairness, quote unquote, to all parties, we thought what was good for the goose and the primaries, where everybody was randomized and no one candidate had preference, was probably the right way to go and more fair. And I believe the testimony was, you know, if voters really are that smart, then it doesn't matter if they're randomized or not. So the question is, do you think that there's a ballot effect? And I'll tell you, in my precincts, in the primary, the precincts where I'm first in the ballot, I've always had about a 2% bump across the board. After doing this 10 times, I kind of generally know what my votes are going to be. And it just is. It's 2 to 5% according to thousands of studies they have run from our nation's political science programs that says there is in fact a 3 to 5% bump for who is ever the first name on the ballot. So whether that matters or not, I at least wanted to explain. I don't think it was a resounding defeat last year. It was close, and that's why it became an interim topic. Vote your conscience, vote your party, whatever you feel you need to do. But that's the reason that it came to the floor this year.
Representative Ward?
Thank you, Mr. Speaker. To me, it appears, and I urge a no vote on this, to me, it appears that you could, as an independent, enlisting your party on the ballot, say that you're a Republican or a Democrat after having lost a primary. I don't see anything in this bill that precludes you from doing that. And that seems like a really bad idea. You could have 2 Republicans, 2 Democrats in the general election, for example. Maybe you can explain to me why that can't happen, but it appears to me that it could happen from this bill. Thank you.
Representative Yin?
So, Mr. Chairman, just to clarify a little bit, the standing committee amendment removed that part. The only part of the bill that's left is the ballot randomization portion. If you're running as an independent, you are still, even if this bill passes, you're still not allowed to write your party affiliation next to it. You are running as an independent. To refer to the Speaker Pro Temp's comments, the questions about our current system is not broken, I want to make sure that we all remember that he said that, because we have lots of election bills. And I think that as laboratories of democracies for each of our states, it is incumbent for us to find what is the best most representative method to make sure that we represent our constituencies. And one of the highlights I saw on the Wyoming Secretary of State's Facebook page the other day was that one of his goals is to make sure that we increase confidence in our elections. I think this bill is one of those things. We've seen the data that says there is a bump if you're on the top of the ballot. I want to make sure that not a single person has in doubt within our electorate, let alone in our body, that they are confidently elected. And this is one more thing that can increase the confidence of our elections. And so I urge you to vote aye.
Are you ready for the question? Question being called. All those in favor of Chairman Olson's motion that when the committee of the whole rises to report, it does so with the recommendation that House Bill 55 do pass. All those in favor say aye. Opposed, no? No. The chair is in question. All those in favor, please stand. All those against, please rise. House Bill 55 has failed the Committee of the Whole. The next bill for our consideration. Oh, okay. We will do a roll call vote. Oh, okay. Pursuant to House Rule 6-6B, the bill having failed a voice vote, a standing division vote is required. And then having failed a standing division, a roll call is required. The chief clerk will call the roll.
Ellerman? No. Allred? Andrew? No. Angelos? Angelos? Banks? No. Bear? No. Berger? No. Brown? No. Burkhart? No. Byron? No. Chadwick? No. Chestick? Aye. Clouston? No. Conrad? No. Crago? No. Davis? No. Eklund? No. Haroldson? No. Harshman? No. Heiner? No. Henderson? No. Hornock? No. Jennings? No. Knapp? No. Larson Lloyd? No. Larson JT?
Aye.
Lawley? Locke? No. Nyman? No. Newsom excused. Nicholas? Nemec? Northrop? No. Oakley? Obermuller? O'Hearn? No. Olson? Olson? No. Ottman? Pendergraft? No. Penn? No. Provenza? Rodriguez Williams? No. Sherwood? Singh? Slagle? No. Smith? No. Stith? No. Storr? Strzok? No. Stivar? No. Tarver? No. Trujillo? No. Walters? No. Ward? No. Washut? No. Western? No. Winter? No. Wiley? No. Yin? Zwanitzer Dan? Zwanitzer Dave? Speaker Summers? No. Angelos? No. Nicholas? Are there any changes? Oakley? Aye to no. Allred? Aye to no. O'Hearn? No to aye. Further changes? Closing vote? Vote closed. 12 aye, 49 no, 1 excused.
Pursuant to House Rule 6-6B, House Bill 55, having failed a roll call vote, is indefinitely postponed. Let's see. The next bill for our consideration is House Bill 69. The reading clerk will read the bill.
House Bill 69, sponsored by Representative Larson. Coal-fired facility closures, litigation funding amendments. Mr. Speaker, your committee number 9, Minerals, Business and Economic Development, to whom was referred House Bill 9, coal-fired facility closures, litigation funding amendments. Respectfully report same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Banks, Burkhart, Conrad, Heiner, Knapp, Larson, Lawley, Tarver, Western. Representative Burkhart, Chairman.
You have heard the reading of the bill. What is your pleasure, Chairman Burkhart?
Thank you, Mr. Chairman. I move that when the Committee of the Whole rise to report, it do so with the recommendation that House Bill 69 do pass. I further move the Standing Committee amendment and turn the explanation of the bill over to the good representative from roughly the center of the state, and at the appropriate time, I will handle the amendment.
Representative Larson Lloyd.
Thank you, Mr. Chairman. Members of the House, in 2021, we were endeavoring to be able to move our clean Powder River Basin coal to global markets through a port on the western side of the U.S. And there was a state there that prohibited us from doing such, and in doing so, we entered into litigation. The good representative from town north of here, where the Bulldogs are at, put in that bill, suggested that we help fund any litigation defending that type of action. And in the course of the year, there was an attempt to take that action to the Supreme Court, and the Supreme Court decided not to do anything with it. That money has stayed there, and we contemplated last year taking this money and expanding the use for defending and prosecuting lawsuits against coal. We ran out of time last year, so we're bringing it back this year, and we're expanding it a little because things are done. And so what we do in here is we say that the governor, for the purposes of intervening in and defending lawsuits against, and we expand it now to say federal government and its agencies, and then the existing languages, states and their languages and their agencies, and by the federal government and other states and or third parties. And we add language to say that that would cause early retirement of coal-fired generation facilities located in Wyoming, or that would result, this is new language, result in the decreased use of Wyoming coal or closure to coal-fired electric generation facilities that use Wyoming coal. What's interesting with this is since over the past 2 decades, there's been a real effort to reduce coal-fired generation, even though their emissions have dropped over 80%. And we know that the stability of baseline generation from coal-fired plants is second, maybe only to nuclear, but has just been the backbone of nuclear generation in the U.S. What we find is we continue to find efforts to try to close down prematurely coal-fired plants, and we have, I'll give you a couple examples of what is happening in, there's a state that's known for Boilermakers that had a couple of plants that have a regulated monopoly utility who is requesting permission from the Public Service Commission of that state to retire a significant number of about 2,000 megawatts of coal capacity and replace it with 3,900 megawatts of wind and solar. It's a fair argument to say that a private utility can do what it wants to do, but what we found out in this is these coal-fired generation plants use Powder River Basin coal, is that this regulated monopoly perhaps wasn't as transparent with the Public Service Commission and the rate shareholders as they were suggesting. They were anticipating that their wind generation would be around 15%. They relocated it to a place that only has 7.4%, or it means that it would only produce electricity 7.4% of the time. It was not. It inflated the cost it inflated the cost to run the coal plants based on the unanticipated tax on coal. At the end of the day, the utility justified the plant closures by comparing inflated coal costs with their alternative energy. And and then they wanted to have an additional $25 million a year annually for accelerated depreciation of those plants, with an increase of rates to the customers, whereas none of that was necessary if they just continued on with the coal-fired generation till they were ready to be retired. Another example, Mr. Chairman, in the land of Razorbacks, the federal government with its their regional haze plan, kind of done a quick one here recently. They had established that that regional haze plan in 2012. Then they come back and move the target up to on the industry up to emissions in 2016 after a number of implementations had been made and cleaned the air up. So they moved the target. And then in this one specific example, they are requiring 2 plants to be closed for utility that would not be required to make any changes in their scrubbers, wouldn't require any BART action, but allowed them to remain open 5 other plants that would require about $2.6 billion in changes. Those changes to those impacts on Wyoming over the course of that would be about $264 million in taxes from Powder River Basin coal. So I'd ask for your support. And Mr. Chairman, I might just, and I apologize to the committee in getting into the detail too much, but we also need to expand that because there's some public utilities or local utilities that also have these plants. And so I'd like to turn the explanation of the standing committee amendment.
Chairman Burkhart.
Thank you, Mr. Chairman. I believe there are some comments and questions on the bill itself. I think they should be handled before we go to the amendment.
Representative Conrad.
Thank you, Mr. Chairman. I do want to emphasize a number of points that were made previously by our distinguished representative earlier. This is not only about power plants. Recognize that as we talk about minerals, which is one of the solid foundations of our revenue in the state, it directly impacts the southwest corner, specifically in the soda ash industry. There are a number of plants there that are supplied by coal that produce their steam that's necessary to provide a profitability for this state. The competitiveness now that we see based on China imports, et cetera, is directly in combat with our ability to produce economically. This inability to utilize coal, more importantly, have our governor have the ability to litigate these issues is extremely critical. I want to share, I do vote and ask for your favorable consideration on this specifically to allow him to do so. Many of us will remember in 2014, there was an issue down by the Jim Bridger power plant where they were required to put in SCRs, an astronomical amount of money. Fortunately, the governor took the EPA to court, and today we still see, at this point, Jim Bridger still producing power, et cetera. Giving the governor this ability is critical for our industry because right now the capital expenses based on supply chain and other issues is critical that we would never be able to meet the increased demands upon soda ash production, specifically on the restrictions that are being based and put on coal. Coal will likely never be outlawed, but what will happen is they will restrict the ability through environmental regulations to not allow us to produce through regional haze, through particulate matter 10 to 2.5, et cetera. This is a critical bill for us, for those who are in the southwest corner, and the amount of money and the generation that it produces, not only locally, but through economic development, through state revenue, but also our employees in the southwest corner, which are critically vital, important to our local economy. So again, I strongly urge you for your favorable consideration in supporting this bill. Thank you.
Representative Haroldson.
Thank you, Mr. Chairman. 2 years ago, 2021, we brought 207, which put this funding into an account. So the money's already there. You need to realize that. And I'm not saying anyone didn't understand that, but just so you do, because if you're looking at the fiscal note and going, wow, we're spending money, we're not. This is already there. We're just opening up the gate, so to speak, to what it can actually be used to protect. Ultimately, originally, it was based on Commerce Clause and protecting our state, that constitutional right we have of the Commerce Clause. And this is opening it up to being beyond that, to where we can use this for protecting our state against anything that would be that regulatory. So definitely on it. Obviously, when I brought 207, my heart was in regards to some issues that we had on the closure of a coal-fired power plant. That has since passed. They found other ways. And so I believe this money is there and can be used by our state to further protect our economy. So definitely on and for.
Representative Burkhart.
Thank you, Mr. Chairman. At this time, I'll address the standing committee amendment to the bill. So if you look at the standing committee amendment, it amends page 2, line 3 after agencies, adds in and local governments. On line 7 after states, inserts local governments. After parties, inserts including corporation, partnership, or other unincorporated associations, which if you read that really broadens this out. And one example is there's a company that has authorization to ship coal out of a port in the Golden Bear State. However, the local community has prohibited the trains from going through their community. So this would allow the state to legally pursue that matter to again ship coal off the West Coast. So I would ask for your favorable consideration and your aye vote on Standing Committee Amendment 1. And Mr. Chairman, you address the amendment first, then the bill.
Question having been called, all those in favor of Standing Committee Amendment number 1, say aye. Opposed, no. Standing Committee Amendment number 1 has passed. We are back on the bill. Question being called, all those in favor of Chairman Burkhart's motion that when the Committee of the Whole rises to report, it does so with the recommendation that House Bill 69 do pass. All those in favor say aye. Opposed, no. House Bill 69 has passed the Committee of the Whole. The next bill for our consideration is House Bill 73. The reading clerk will read the bill.
House Bill 73, sponsored by Representative Stivar. Annexation, vote requirement, an act relating to cities and towns. Mr. Speaker, your committee number 7, Corporations, Elections, and Political Subdivisions, to whom's referred House Bill 73, annexation, vote requirement. Respectful report, same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Chadwick, Haroldson, Harshman, Knapp, Olson, Ottman, Wiley. Noes, Representative Yen. Excused, Representative Newsom. Representative Olson, Chairman.
You have heard the reading of the bill. What is your pleasure, Chairman Olson?
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report, that it do so with the recommendation that House Bill 73 do pass. I further move the adoption of Standing Committee Amendment number 1 to House Bill 73 and ask for your favorable consideration. I'll have to explain the Standing Committee Amendment later because it just won't make a lot of sense without the author of the bill first presenting the bill. So I'll turn over the management, the floor management of this bill to the author, the esteemed representative from House District 12.
Representative Stivar.
Thank you, Mr. Chairman. I bring you House Bill 73. The reason I'm bringing House Bill 73 is on the annexation of voting. People are buying their property thinking they're going to be in the county. We all went out and bought things. Things change. But the municipalities are skirting around some of the statutes. So in statute, on page 15.1402, I've just added a paragraph. VII, not fewer than 2/3 of the
landowners owning a majority of the property sought to be annexed, excluding public streets, alleys, and tax-exempt properties, have approved in writing the proposed annexation by responding to the notice in paragraph VI of the subsection, or otherwise notifying the city or town in writing of their approval of the proposed annexation. All right, I've talked, this is a really big problem in my district. I've talked to people in southwestern Wyoming that's ran into the same problems of not being notified. This just puts a little more meat into the annexation and to get the information out there. Questions?
Is there any discussion on the
Vote
amendment?
aye.
Representative Brown.
Thank you, Mr. Chairman. I guess, and I apologize, I don't quite understand what this bill does. It gives more meat to that process. So what exactly are we trying to do? What problem are we trying to solve? I think I understand, but reading the language of the bill and hearing what you were just saying, it's kind of it doesn't quite make exact sense. So if I can get a little bit of a layman's terms of understanding of what exactly we're accomplishing with this bill, I'd appreciate it.
Representative Stivar. Representative Hornock.
Mr. Chairman, are we on the amendment? Are we on the bill?
We're on the bill.
The bill? Well, let me just talk about the bill a little bit. So one of the issues that we do have here in Laramie County is I understand that there's a lot of pockets of county properties within the city of Laramie. You probably have some in your towns that you represent as well. There's a lot of people who move close to the city that are within a radius of that city. And the city, obviously, there's incentive for the city to annex into the city because of the mill levies, the property tax, and other incentives. There's also a financial burden a little bit on the city. You know, you have to provide fire, things like that. One of the things that was not really brought up that I think this bill does protect, and I urge you to vote for this bill and actually against the amendment, and I'll speak to that here in a little bit. But so one of the things that was not necessarily brought up was that what happens when a county property is annexed into the city is that it is required of those people being annexed into the city to pay for the utility infrastructure to be brought to their house, their location, their property. That is a huge burden on these people. And so there's a reason why a lot of them don't want to be annexed into the city. They want to stay within the county. There's also the burden on these people where they have to abide by new regulations put upon them. So it limits construction, what they can do with their property. It limits what they can do with their business that's on their property. It limits what they can do with parking a trailer on their property. Whatever that is, it really limits and hinders the private property ownership and sets regulations upon that. So I urge you to vote in favor of this bill, but on the amendment, I would like to urge you to vote no on the amendment because that will take it back to a 2/3 requirement of the people within that pocket trying to be annexed, where 2/3 of them will have to say, yep, I'm okay with this. What happens oftentimes with...
So if you can just stick with the bill and then we'll come to the amendment.
Thank you.
Representative Swanitzer.
Yeah, thank you, Mr. Chairman. Just a question maybe for the committee, and I missed this hearing. is there any trepidation or fear that the bill doesn't become effective until July? And we may have some of our municipalities trying to enact annexations before that July date? Not sure if that was discussed, just want to know if anybody else is having that suspicion.
Representative Wiley.
Yeah, I would just like to speak in favor of this. I think it's a good step for private property rights and for folks that have small parcels of land and stuff that are outside of city limits. And this would require the townships or the cities to actually inform them and make sure that they get a hold of them instead of just putting in a certain time period of, right now it's 20 days. If you miss your 20 days, well, you're annexed. What this does is they will have to approach them, educate them, and then these folks can get together and choose if they want to be annexed or not. I'm in support of this bill. I think it's a good piece of legislation. Thanks.
Representative Trujillo.
I'd also like to speak in favor of this bill. My district borders county property, and I have residents in my district that will be deeply affected by this. And it doesn't stop the trickle effect of annexation, because once the city goes in, then they have that limit, and a couple years from then they can annex again, and it doesn't stop. So I'm in favor of this bill.
Representative Sherwood.
Thank you, Mr. Speaker. I'm wondering if the good bringer of the bill could just offer some insight to pros and cons on requiring responding in writing only for those who approve. Wouldn't it be equally as valuable to get documentation from those who disapprove? Thank you.
Representative Singh.
Thank you, Mr. Chair. I just wanted to stand up and say that I support this. A lot of folks in my community are affected by this specific problem, and they moved to the properties that they chose specifically because it was in the county. And I think it's only fair that they have a say in that process of being incorporated into a larger community. Thank you.
Representative Jennings.
Thank you, Mr. Chairman. So a couple of speakers before, I think the people that disapprove, they're pretty good about getting out and speaking about it, so I don't feel too uncomfortable with that. I like this bill because it brings transparency and good accountability. Vote yes on the bill.
Representative Stivar.
Thank you, Mr. Chairman. To answer Representative Brown's question, is the transparency and open it up to let everybody know what's out there. So, vote aye.
Representative Brown.
Thank you, Mr. Chairman. I guess I wanted to ask a question on the mechanics of the bill as well. If you look at the second paragraph, it states that this would be required, and I'm not actually against this bill. I think this is probably a pretty good, sound piece of legislation, but I am curious on the mechanics of if it requires those that are approving to write an agreement, and nobody can do this, is that a single piece of information representing everybody and combining this all into one piece of paper that brings it forward? Is this a written documentation from every single person in that area that is at least a 2/3 vote? What are the mechanics of this, and how do they operate? Thank you.
All right.
Representative Stivar, and I just would like to remind the House that
thank you
to not invoke someone's name at the mic.
To answer the good representative's question, the annexing municipality has to send a registered letter out 20 days prior to the annexation meeting. That's where they will have to be notified, and then they can go back with the card or whatever, however the city decides to get the information back to them if they're voting yes or no on the annexation. It'll be put in the first part of that, as the registered letters being notified.
Representative Stith.
Mr. Chairman, just a question for the sponsor. the language right now appears to require a vote of 2/3 of the landowners owning a majority of the land. So in a situation where, say, north of a municipality, you have 1,000 people living on 20 acres, and then you have a single landowner who owns 40 acres, and the city wants to take all 60 acres, would that mean that one person who owns the 40 acres, could veto the annexation? Is that what the language means?
That's my understanding.
Representative Stiver. Any further discussion? We need to move an amendment.
Hi, Mr. Chairman.
Representative Olson.
Yep, thank you. I've already moved the amendment, actually, but I'll discuss it. So this is a opportune moment for the amendment to come up based on the comments from the Speaker Pro Tem. The amendment deals with the 2/3 vote. You could probably read this two ways. What the amendment does is it moves the 2/3 threshold down to a majority, but it also eliminates the provision that the Speaker Pro Tem just spoke about, the majority of the land, by replacing it with simply the word parcel. So under this amendment, we're saying 51% of those owning parcels in the area to be annexed must approve. So the way I read that, interestingly, the way I read that is this is actually a more strict requirement than the existing bill, based on the example the Speaker Pro Tem just pointed out, where one person sitting on the majority of acreage could veto the annexation. Here, under this amendment, they couldn't do that. It requires 51% of the people, period, who own parcels, regardless of the size of the parcel. So the idea of the amendment, though, I'll tell you, is really, it's a policy choice for you as a body. The committee was concerned that with apathy, you look at an election and less than 40% of residents show up to an election, how are they going to show up even to answer the question of annexation? So lowering that, an attempt to lower that threshold, though I think as I read through this committee amendment more, I think it actually makes the burden even more difficult for a city to annex under the existing language. The last piece of the amendment is the effective date. The bill is effective July 1, 2023, but this amendment is effective immediately upon its passage and signature by the chief executive. And the purpose for that is, we heard on this particular bill substantial testimony. There were numerous individuals, the majority, if not all of them, were here from Laramie County testifying on this bill. We heard numerous instances of procedural issues with existing annexations, potentially to an extreme of some citizens not even allegedly receiving their notices. And so this gave the committee concern that if we wait until a July 1 effective date, that there could be more issues that arise. So this won't affect. The key to this bill to really understand, though, is this won't impact any current annexation that has already started in a process. This will only be annexations going forward, but in our attempt to mitigate some of those concerns for citizens, we made it effective immediately. So that's the standing committee amendment. Vote your conscience on it. Thank you, Mr. Chairman.
Representative Hornock.
Thank you, Mr. Chairman. On the amendment, I would urge a no vote on the amendment, and let me just kind of explain briefly. This bill, as originally written, I think was fine. It helps our citizens when it comes to that annexation process, and it puts more of the power in their control. There's things that I like about the amendment, but I think the original bill actually helps more than adding the amendment to it. So what often happens, going from a majority to 2/3 or 2/3 to a majority, one of the two, what often happens, at least here in this city, is that when a developer comes in and buys a piece of property, the city requires them to annex into the city. So at that point in time, you're dealing with one person in this developer, and if the developer wants to move forward with their development, then they're okay with that. They just bought a bunch of property, and oftentimes they want to bring the city services, the utilities, the sewer, the water, the electrical, they want to bring that to their development, which is fine. And so you're dealing with whether it's, at that point in time, one person owns the land, you've got the 2/3 at that point in time. What the 2/3 will do, though, is allow a group of property owners that have been there for years or that have bought a piece of property in a section specifically because it was in the county and they want to have a little bit of more latitude than they would otherwise in the city. It would allow that group to kind of come together and to network with each other and figure out what they want to do. It will put the ability to approve that annexation more on the neighborhood group, and I think that's where we need to keep it. So I urge you to actually vote no on the amendment, yes on the bill. I think the amendment, the bill as originally written without this amendment was fine in and of itself. Thank you, Mr. Chairman.
Representative Heiner.
Thank you, Mr. Chairman. I am for the bill, but against the amendment, and I'll tell you why. I'm as the majority floor leader calls, I'm all hat, no cows. I'm not a rancher. I don't have any cattle, but I had one of my ranchers call me just last night, and they are very concerned about this amendment because they own 600 acres just outside the city limits. And there's several homes outside the city limits also. So in this scenario, with this amendment, it's based on population or parcels, not acreage. So the city could annex this rancher's property without them ever being agreeable to it. Just the subdivision, or not the subdivision, but the homeowners in that area could agree to it and force this rancher to be within the city limits. And we all know what that does to taxes as you're inside city limits, planning and zoning requirements and all of that. So with the original bill, it's based on majority, and I assume that's acreage, so that the landowners that would actually be taxed had a say. They call that taxation without representation. With the amendment, I'm afraid that would happen, and it would cause some individual ranchers to be drawn in when they really don't want to be. So I'm against this amendment, but I think it's a great bill. Thank you.
Representative Brown.
Thank you, Mr. Chairman. I hate to do this, body, but there are good portions of this amendment, and there are some bad portions of this amendment. So I'm going to move to divide this amendment. Mr. Chairman, Division 1 would be lines 1 through 7 and lines 18 through 21. Division 2 would be lines 8 through 16. And Division 3 would be lines 23 through 30.
The chamber will stand at ease while the chair considers if it's divisible. Okay, so
which division,
Division 1 is line 1 through 7.
And what?
Representative Brown, could you please come to the front? The House will come to order. Representative Brown, if you could please explain the division again.
Thank you, Mr. Chairman. I'll wait for the body to get settled back in and we get a little bit of quiet, and I'll re-go over the division with everybody just so we have it completely squared away. So there was some confusion. Division 1 encompasses more than just the first lines that I mentioned. So I will go over this slowly and carefully with everybody. Division 1 is lines 1 through 7, as well as lines 17 through 21. That's Division 1. Division 2 would be lines 23 through 30. And Division 3 would be lines 8 through 17. So in essence, the three divisions would be the 2/3 to simple majority, the effective date, and then the annexation to 550 feet.
The chair rules that is divisible. Which one would you like to go first, second, and then third?
Mr. Chairman, I'll take first division first, please.
Proceed.
Thank you, Mr. Chairman. Ladies and gentlemen, this is the part that I actually think is probably the most important of the entire bill. Recognizing, I think this is a vote up or vote down. I don't really have a personal opinion on this, but I think this is probably the most representative of what this bill actually encompasses, is whether or not we want to have 66% of the landowners in the area being represented and have to have that approval, or whether we want 50%. Personally, I think this is a policy choice for the body. I personally look at this and I say I think 50% is good, because although we hear right now, we've been hearing that there's a lot of people who aren't interested in this, there are some of those county residents who are interested in this, who would like to have trash service and or water and sewer hookups instead of having a leach field or something along those lines. So allowing a 50%, in my opinion, is the right way to go. But I will adjust that and allow the body to have the discussion over this. I think it's a policy discussion for all of us to kind of contemplate. It does seem like the majority of what we're going to be hearing about happens in some of the larger communities here. And so I think that's where we're going to hear the majority of this discussion coming from. But I think it's important to remember that while I've seen more Cheyenne legislators popping up to the mic because this happens to be an issue that's occurring here right now. But when we make policy, we affect the entire state. And I think it's important to make sure that when we affect the entire state, that we recognize that a 2/3 threshold, again, as we just had this discussion a few days ago on our rules, is a very high bar to set. And so I do think that a 50% threshold, especially when it comes to property values, 50 plus 1% is not that much of a task to hit. And I think it's more appropriate than asking for 66%. Thank you, Mr. Speaker, or Mr. Chairman.
Representative Hornock.
Thank you, Mr. Chair. To speak to the amendment and address a couple of things that were said. So I am against this amendment. I think 2/3 is where we should set this for the sake of the people. One of the things that was mentioned in the last, by the last representative, by the last speaker, was that if you want to bring in, some people might want to tie into city services, city water, city utilities. Even within the county, there are mechanisms where you can do that. You can sign an outside user agreement and you can bring those services to your property, even within the county. The fees, at least in this area, I'm not sure how it is throughout the state, but the fees are a little bit higher for you. But if you want to bring those services to your property out within the county and tie into city services, you still can do that if you own property within the county. So by voting against this amendment, it does not preclude you to be able to do that. Thank you.
Just to remind everyone, we are on Division 1, not on the whole amendment. Representative Knapp.
Mr. Chairman, thank you. On Division 1, I would vote in favor of this for the simple majority. You know, in committee, we did hear from numerous residents about not wanting to be annexed, and I think it's our desire to protect those residents. But as a former county commissioner for 12 years, we did hear in numerous cases where communities did want to be annexed. And I think it's our duty to also represent those people with failed water wells, failed septic systems, roads, even relief from unmanaged improvement service districts and water districts. And so as we represent our entire communities, I think it's important that we do so to both sides and make it fair, both on those residents that do not want to be annexed as well as those residents that do.
Speaker Pro Tem Stith.
Mr. Chairman, thank you. In part, I have a question. I was struck by the comment by the representative from District 18. And it seems like in this Division 1, we have two things going on, because we're not just changing it from 2/3 to a majority, but we're also changing whether it's the amount of area to the number of parcels. And so I guess my question is, it seems to me that the representative from District 18 has a point that it could be somewhat problematic that you've got, 100 people who each own 1/3 of an acre, and then you've got one person who owns 100 acres, but the person who owns the 100 acres gets outvoted on this. It's the way it reads to me. So my question kind of is to clarify what this division is actually doing. Anyone who wants to explain that, I'd be happy to listen. Thank you.
Representative Craigo.
Thank you, Mr. Chairman. So I was just, the good Speaker Pro Tem just brought up exactly what I was coming to the mic to talk about, which is there's essentially a veto allowed for landowners, especially if you own if you own a large acreage, for example, but there are 100 people next to you that want to annex, and it's in 15-1-406. Part B, and it just says if more than 50% of the landowners, or if a landowner or landowners owning more than 50% of the area to be annexed file written objections with the clerk of the annexing municipality within 20 business days after the hearing under 15-1-405, which is the annexation hearing, no further action under 15-1-404, the annexation statute, may be taken on any area within the proposed annexation within 2 years. So essentially, you have veto power if you own more than 50% of the landmass to be annexed, even if there's 100 others. So there is protection for our rural ag landowners built into the statute already. I'm not sure how that plays into the 2/3 versus 1/2, but I thought it's worthy for the body to know.
Representative Heiner.
Thank you, Mr. Chairman. I am grateful for our attorneys that we have here in the body. I'm only about 4 or 5 years away from becoming an attorney if I should decide to pursue that. But I appreciate their knowledge, their life skills, and all of their education. That clarifies a lot of things for us. But members, I just want to point out that there are advantages to being within a city limit. We've talked about some of those things. There are advantages to being outside of the city limits. Some people that build homes outside of the city limit do it on purpose. They want to have chickens or a cow or two, or maybe horses. And so they live outside the city limits. And so once the city limits are expanded, they may or may not have to change their lifestyle. They may or may not be able to have chickens, depending on what the city ordinances are. They may or may not be able to have a horse for their children to ride around with. So it's a big step to be annexed. And to do just a simple majority, there may be some disappointed people that have built their lifestyle about being in the country, and then all of a sudden be called city folk. So I think a 2/3 majority is something that would be important in such a big step change for these individuals. I don't want them to be drug into the city limits just based upon a 51%. I appreciate the clarification on parcel. That's very, very beneficial for this discussion. Thank you.
Representative Yin.
Thank you, Mr. Chairman. So this is making me scratch my head more than I would like. The two-thirds majority, the two-thirds of a simple majority versus a majority of those who own parcels are quite different numbers, and especially when we're talking about annexation. If you have, so maybe an interesting scenario, let's say you are a landowner, you have a lot of land, you're actually looking to leave town, but you want to make the most profit of your land as possible, and you make a really nice deal with the neighboring adjacent city and say, you know, let's do something where we can build a subdivision or a development in my land, but the consequence of that is that you have to annex it, but all your neighbors don't want you to have to annex it, but you end up being the majority owner for the surrounding area, right? Because you're a large ranch owner and you have a majority of that land. If we keep the requirement, if we say that the one landowner who owns more than 50% of that land can still have the ability to cause an annexation outside of the power of the neighbors, is that an unintended consequence of the bill as written? So another thought, because the veto power that the good lawyer mentioned is I'm not sure even possible if that landowner owns the majority, because the other folks wouldn't be able to object to that annexation. Maybe I'm wrong, but I'm still scratching my head.
Any other discussion on Division 1? Representative Brown.
Thank you, Mr. Speaker, or Mr. Chairman. I'm thoroughly confused as well. So I think if anything, that shows that the good bringer of the bill should probably be working on some good cleanup language for a second reading amendment if this so passes. Because also hearing from the good country lawyer some of the annexation veto power that we have out there, I think we've done talked ourselves into a spiral here that we may not be able to get out of. So, question on Division 1.
Question on Division 1 being called. All those in favor, please signify by saying aye. Opposed, no. Division 1 fails. We are now on Division 2. Representative Brown.
Thank you, Mr. Chairman. So Division 2 is the effective date, I think, if I remember right, how I divided this. Is that correct? Okay. I actually really like this. And I think that as the good chair of Labor Health brought up some of the unintended consequences of passing a bill that may not take effect until July 1st, we actually have some of these situations already occurring. So I would encourage an aye vote on this one. Let's get this bill into existence and get it rolling as soon as possible.
Question on Division 2 being called. All those in favor, please signify by saying aye. Aye. Opposed, no. Division 2 passes. We are now on Division 3. Representative Brown.
All right, thank you, Mr. Chairman. I guess on this one, this is truly a decision for this body to make of, do we want somebody that has bordering property to decide whether or not the people who are actually going to be affected inside of the annexation to actually have any authority on this particular process? And that's really what we're talking about. 550 feet, you know, that's a pretty significant distance. I'm trying to remember what our setbacks are for oil and gas rigs. I think we have setbacks in similar distances there. You know, do we have the authority for somebody to sit there and pull an oil rig out because of a setback of 500 feet? I don't know the cases that we want to do that. So policy choice for the body. I hope there's a little bit of discussion on this one, but vote your conscience.
Chairman Olson.
Sorry, thank you, Mr. Chairman. Just to clarify, from the last speaker's comments. This provision, very specifically on page 2, line 15, it's just amending, it's just speaking to those who receive notice. So we got two different components in the bill: notice and those actually who have to vote or be a part of the 2/3 majority to approve annexation. This is just saying that if any person owns property adjacent to or within 550 feet of the territory proposed to be annexed, that they have to receive a special notice. That's all. This is just a notice requirement. And this particular amendment, to give you some edification, this was brought to us by those association of people who deal with real property, felt that this was necessary in order to protect private property rights. So that's why we added this into the Standing Committee amendment. Hopefully that clarifies for the body. Thank you, Mr. Chairman.
Representative Hornock.
Mr. Chairman, thank you. Just to let you know, there is a process. For the example that was used for a person that owns a large portion of property that doesn't want the other landowners around them to help them influence the decision. There are ways around that. You can replat your land. You can put that buffer around your land so that only you are voting for this on your piece of property, and that would kind of make a green space or something around your land as well. So anyway, there's ways around this to if you wanted to go that direction. So I would encourage an aye vote on this amendment.
Representative Brown.
Thank you, Mr. Chairman. I'll speak on this last piece here. I would just say I like the taste of crow, apparently. I will eat it more often than I'd like. So I appreciate the good chairman of corporations for bringing that forward, and I would say this is a good amendment, so vote aye.
Representative O'Hearn.
Thank you, Mr. Chairman. Vote aye on the amendment and no on the bill.
Question being called on Division 3. All those in favor of Division 3, please signify by saying aye. Aye. Opposed, no. Division 3 passes. Question has been called on all those in favor of. We're back on the bill. Representative Walters.
Thank you, Mr. Chairman. I'm going to encourage a no vote on this. We're amending one particular part of the statute regarding annexation, but if you go look and read the entirety of the annexation statutes, a lot of the concerns that have been brought up by the folks that have came to the microphones this afternoon are addressed, and they're addressed very well. We discuss if a landowner is raising cattle on their property and now all of a sudden they're annexed in. If you go to 15.1.410, that's discussed that as long as the activity was taking place 1 year prior to and in continuous use of, those activities will be allowed to continue and cannot be infringed. And I'm just paraphrasing. And any subsequent owner of that property is allowed those same activity rights as long as they follow that continuous use. So again, that was a question. Expecting people to change what they're doing because they're annexed in. There's statutes sections regarding the property owners initiating the annexation process. You know, it's been discussed under the assumption that annexation is always taking place because a city or a town is trying to come in and bring more land into that municipality. There's, like I said, there's a process to allow the landowners in the area to go ahead and initiate the process. There's several checks to allow for rejection of this. There's lots of public notice. And so I think we've had a lot of questions that are only being addressed because we're talking about just what's on that bill in front of us without going and reading the entire annexation statute. So again, I would encourage a no vote on the bill, and thank you for your time.
Any further discussion on the bill? Representative Stivar.
Thank you, Mr. Chairman. Comments from the last speaker. This is adding to the one section of the annexation statutes, 15.102, adding another paragraph to that because in my belief and my constituents, They're not getting notified. Over in the town that's got the town triangle, the one town annexed all the way around that town. So you've got a town in the middle surrounded by the other town. And they're not getting the services by statutes, and they can't opt out. Same thing in over in the southwestern corner of the state. There's a homeowner association that got annexed into the city 10 years ago. They're still paying for garbage services to come from Sweetwater County over to the other county to haul their garbages. All this does is make sure that they have to be notified to be for more transparency. Vote aye on the bill.
Question being called, assuming there's no one else speaking on the bill. All those in favor of Chairman Olson's motion that when the committee of the whole rises to report, it does so with the recommendation that House Bill 73 do pass. All those in favor say aye. Aye. Opposed, no. House Bill 73 has passed the committee of the whole. The next bill for our consideration is House Bill 18. The reading clerk will read the bill.
House Bill 18, sponsored by Tribal, Missing Persons Alert Systems, an act relating to missing persons alert systems. Mr. Speaker, your committee number 10, Labor, Health, and Social Services, to whom was referred House Bill 18, Missing Persons Alert Systems, respectfully reports same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Chadwick, Houston, Hornick, O'Hearn, Penn, Trujillo, Ward, Yin, Zwanitzer. Representative Zwanitzer, Chairman.
You have heard the reading of the bill. What is your pleasure, Chairman Zwanitzer?
Thank you, Mr. Chairman. I move when the committee of the whole rise to report it, do so the recommendation that House Bill 18 do pass. There is one standing committee amendment, which I'll take on before I turn the bill over. And so, members, this is on the missing person alert systems. You heard our chief executive talk about this very issue in the state of the state. You can see the vote from our committee on labor and health. And so what this does is expand the alert system if there's a missing person, as you can see within the bill. And I'll certainly let the chairman of the Tribal Affairs Committee talk about the bill, but let me just knock out the standing committee amendment. This is simply a specifier that we're adding America's Missing Broadcast Emergency Response Alert Criteria. That's the federal law that goes along with the current alert system. It's a color. You get that on your phones without using a proper name. And so this is establishing just a clarification in our law of which alert system we're talking about. Be happy to answer any question on the standing committee amendment at this time.
You've heard question having been called. All those in favor of standing committee amendment number 1, please say aye. Aye. Opposed, no. Standing committee amendment number 1 has been adopted. We are back on the bill.
Thank you, Mr. Chairman. I'd be happy to turn over explanation of the bill to the good Vice Chairman of Appropriations.
Representative Larson Lloyd.
Thank you, Mr. Chairman. I think this body remembers that the Select Committee on Tribal Relations over the last few years has done a lot of work in implementing the statutes for missing and murdered persons in Wyoming and putting into place an Amber Alert that coordinated our activities between the state, federal, and tribal officials for children that are missing. This addition of language in this bill really reflects a recent federal act that was enacted because of a young lady back in Virginia that was missing. She was 17 years old and she was missing. They found her a few weeks later, about 350 miles away from her home, and she had been murdered. And The reason that there's no mechanism to do an Amber Alert for someone over the age of 17. And so they enacted the law, it's called the Ashanti Law, named after this young gal, Billy Ashanti, to allow us to put into place the warning system for adults, and it means an adult at risk, and you'll see this on page 5, means an adult that has developmental disability who suffers from Alzheimer's or dementia, or who suffers from or could, without access to medication, suffer from cognitive impairment if the impairment would likely render the adult incapable of getting to a familiar location without assistance. So we're just enhancing the ability when we have people, folks in this situation who are adults at risk, or women or others who come up missing, that we can have Amber Alerts. And this actually falls into another category other than Amber Alerts. Or Highway Patrol are not required to have statute to implement it, and are in the process. We just want to have it on the books to make sure that it stays there. So I appreciate your support in this bill.
Any other discussion? Question being called. All those in favor of Chairman Zwanitzer's motion that when the committee of the whole rises to report, it does so with the recommendation that House Bill 18 do pass. All those in favor say aye. Aye. Opposed, no. House Bill 18 has passed the committee of the whole. Mr. Majority Floor Leader.
Thank you, Mr. Chairman. I move that the committee of the whole rise and report.
All those in favor say aye. Aye. Opposed, no. We are adjourned. We're
Nice try.
yeah, right. Clear my stuff out of here.
Good job. No, not yet. The reading clerk will read the committee of the whole report.
Mr. Speaker, your committee of the whole, having had under consideration bills on general file, begs leave to report as follows. House Bill 31, do pass amended. House Bill 3, do pass amended. Beg leave to re-rise and return at 1400 hours. Rise. House Bill 47, do pass amended. House Bill 62, do pass. House Bill 12, do pass. House Bill 55 failed to pass committee of the whole and was indefinitely postponed. House Bill 69, do pass amended. House Bill 73, do pass amended. House Bill 18, do pass amended. Representative Larson, JT, Chairman.
I move the adoption of the committee of the whole report.
You have heard the motion. All those in favor say aye. Aye. All those opposed, no. The motion carries. Congratulations, Representative Larson. JT. Nice job, Representative Larson, JT. Messages from the Senate.
Message 118. Mr. Speaker, the bill listed below passed the Senate on third reading in an amended form by the vote indicated. Senate File 7, definition of opiate antagonist amendment. Ayes 31. Message 119. Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. Senate File 9, Medicaid coverage, licensed pharmacists. Ayes 23, noes 8. Message 120. Mr. Speaker, the bill listed below passed the Senate on third reading in an amended form by the vote indicated. Senate File 42, Taxation of Cigars. Ayes 26, noes 5. Message 121. Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. Senate File 47, Education, Repeal of Immunity for Corporal Discipline. Ayes 26, noes 5. Message 122. Mr. Speaker, the bill listed below passed the Senate on third reading in an amended form by the vote indicated. Senate File 63, Tax Administration Revisions. Ayes 31. Message 123. Mr. Speaker, the bill listed below passed the Senate on third reading in an amended form by the vote indicated. Senate File 74, Slow-Moving Vehicles Amendments. Ayes 30, noes 1. Message 124. Mr. Speaker, the bill listed below failed to pass the Senate third reading by the vote indicated. Senate File 73, Lawful Fences. Ayes 4, noes 27. Sincerely, Ellen Thompson, Senate Chief Clerk.
Reports from standing committees.
House Bill 4, sponsored by Labor, Medicaid 12-month postpartum coverage, an act relating to medical assistance and services. Mr. Speaker, your committee number 2, Appropriations, to whom was referred House Bill 4, Medicaid 12-month postpartum coverage, respectfully report, same back to the House with the recommendation that it do pass. Ayes, Representatives Henderson, Larson, Nicholas, Sherwood, Stith, Walters, Zwanitzer. Representative Nicholas, Chairman. House Bill 7, sponsored by Representative Zwanitzer Dan, Underage Marriage Amendments, an act relating to domestic relations. Mr. Speaker, your committee number 3, Revenue, to whom was referred House Bill 7, Underage Marriage Amendments. Respectful report, same back to the House with the recommendation that it do pass. Ayes, Representatives Byron, Harshman, Northrop, Oakley, Storer, Zwanitzer. Noes, Representatives Baer, Locke, Strzok. Representative Harshman, Chairman. House Bill 11, sponsored by Judiciary, State Park Rangers Retirement, an act relating to retirement. Mr. Speaker, your committee number 1, Judiciary, to whom was referred House Bill 11, State Park Rangers Retirement, respectfully report, same back to the House with the recommendation that it do pass. Ayes, Representatives Chestick, Crago, Haroldson, Jennings, Nemec, Oakley, Provenza, Rodriguez-Williams, Washit. Representative Washit, Chairman. House Bill 14, sponsored by Judiciary, Civil Case Filing Fees Amendments, an act relating to courts. Mr. Speaker, your committee number 1, Judiciary, to whom is referred House Bill 14, Civil Case Filing Fees Amendments. Respectfully report, same back to the House with the recommendation that it do pass. Ayes, Representatives Chestick, Crago, Nemec, Oakley, Provenza, Washit. Noes, Representatives Harrelson, Jennings, Rodriguez-Williams. Representative Washit, Chairman. House Bill 33, sponsored by Education, School Finance, Career Technical Education Grants, an act relating to school finance. Mr. Speaker, your committee number 4, Education, to whom is referred House Bill 33, School Finance, Career Technical Education Grants. Respectfully report, same back to the House with the recommendation that it do pass. Ayes, Representatives Allred, Berger, Brown, Klauston, Lawley, Obermuller, Provenza. Excused, Representatives Andrew, Northrop. Representative Obermuller, Vice Chairman. House Bill 26, sponsored by School Facilities. School Facilities Appropriations, an act relating to appropriations for K-12 school facilities. Mr. Speaker, your committee number 2, Appropriations, to whom is referred House Bill 26, School Facilities Appropriations. Respectfully report, same back to the House with the recommendation that it do pass. Ayes, Representatives Henderson, Larson, Nicholas, Sherwood, Stith, Walters, Zwanitzer. Representative Nicholas, Chairman. House Bill 24, sponsored by Capital Finance. State investment, compensation, and relocation amendments, an act relating to the administration of government. Mr. Speaker, your committee number 2, appropriations, to whom is referred House Bill 24, state investments, compensation, and relocation amendments. Respectfully report, same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Henderson, Larson, Nicholas, Sherwood, Stith, Walters, Zwanitzer. Representative Nicholas, Chairman. House Bill 44, sponsored by Transportation, Road and Bridge Construction, Alternative Contracting, an act relating to highways. Mr. Speaker, your committee number 8, Transportation, Highways, and Military Affairs, to whom was referred House Bill 44, Road and Bridge Construction, Alternate Contracting. Respectfully report, same back to the House with the recommendation that it do pass. Ayes, Representatives Berger, Brown, Nemec, Obermueller, O'Hearn, Pendergraft, Smith, Wiley. Noes, Representative Stivar. Representative Brown, Chairman. House Bill 45, sponsored by Transportation, Peace Officer Retirement and Rehiring, an act relating to the administration of government. Mr. Speaker, your committee number 8, Transportation, Highways, and Military Affairs, to whom was referred House Bill 45, Peace Officer Retirement and Rehiring, respectfully report, same back to the House with the recommendation that it do pass. Ayes, Representatives Berger, Brown, Nemec, Obermueller, O'Hearn, Pendergraft, Smith, Stivar, Wiley. Representative Brown, Chairman. House Bill 65, sponsored by Revenue, 988 Suicide Prevention, an act relating to suicide prevention. Mr. Speaker, your committee number 3, Revenue, to whom was referred House Bill 65, 988 Suicide Prevention. Respectfully report, same back to the House with the recommendation that it do pass. Ayes, Representatives Byron, Harshman, Northrup, Oakley, Storer, Zwanitzer. Noes, Representatives Baer, Locke, Strzok. Representative Harshman, Chairman. House Bill 93, sponsored by Water, Omnibus Water Bill Construction, an act relating to water development projects. Mr. Speaker, your committee number 5, Agriculture, State, and Public Lands and Water Resources, to whom was referred House Bill 93, Omnibus Water Bill Construction, respectfully report, same back to the House with the recommendation that it do pass. Ayes, Representatives Alamand, Allred, Banks, Conrad, Crago, Davis, Eklund, Slagle, Winter. Representative Eklund, Chairman. House Bill 81, sponsored by Representative Larson Lloyd. Hospital supplemental payments, statutory fix, an act relating to medical assistance and services. Mr. Speaker, your committee number 10, Labor, Health, and Social Services, to whom is referred House Bill 81, hospital supplemental payments, statutory fix. Respectfully report, same back to the House with the recommendation that do pass with the following amendments. Ayes, Representatives Chadwick, Klauston, O'Hearn, Yin, Zwanitzer. Noes, Representatives Hornock, Penn, Trujillo, and Ward. Representative Zwanitzer, Chairman.
Re-referrals, Chairman Zwanitzer.
Thank you, Mr. Speaker. I would re-refer House Bill 81 to your committee number 2, Appropriations.
Seeing no objection, House Bill 82 is re-referred to committee number 2, Appropriations. Chair, 81, excuse me, 81 is re-referred to committee number 2. Chairman Eklund, would that come out of Ag? I assume 93, it's the water bill. Yeah, but 93.
Mr. Speaker,
Chairman Eklund.
I'd like to refer Omnibus Water Bill Construction to, it's House Bill 93 to Appropriations.
Thank you. Seeing no objection, House Bill 93 is re-referred to committee number 2, Appropriations. Mr. Majority Floor Leader. You're just, Mr. Majority Floor Leader.
Thank you, Mr. Speaker. I do not have a list currently, but I will put together a list. We're waiting on bills that were just referred from committee. So once I get that list compiled, I will put a list together for you, and we'll have it immediately on the website, so you'll know what's going to be up in the morning. So that'll take care of that. Until then, Mr. Speaker, I move the House adjourn until 10 a.m. tomorrow, January 18th, 2023.
Committee announcements. Chairman Burkhart.
Thank you, Mr. Speaker. Your committee number 9, Minerals Business and Economic Development, will meet at 8 a.m. tomorrow morning and take up House Bill 67, Special License Plate Decal Women's Veterans, House Bill 43, Winter Road Closures, and House Bill 94, Board of Parole Wyoming Residency. The committee will not take up 118, Volunteer Firefighter Pension Funding. That is Representative Newsom's bill, and I've agreed to hold it until she returns next week.
Chairman Olson.
Your committee number 7, House Corporations, Elections, and Political Subdivisions, will meet tomorrow upon noon recess in E005 of the Capitol Extension and online to hear the following House bills: House Bill 49, Municipal Nonpartisan Ranked Choice Elections; House Bill 63, Vacancies in Elected Office; and House Bill 86, Disclosure of Private Cryptographic Keys. Thank you, Mr. Speaker.
Chairman Northrup.
Thank you, Mr. Speaker. Your committee number 4 will meet in House Extension Room 3, where we're going to hear 2 bills: House Bill 34, School Finance Mental Health Services, and House Bill 32, Mill Levy Education Amendments. House Bill 137, Minor Sale and Purchase of Cannabinoid Products and being prohibited, is Representative Newsom's bill, and she also has asked that it be delayed until she comes back. I have an update. Do you mind if I update? Okay.
Please give an update on Chairman Newsom.
All right. She says no surgery. I have to wear a big brace and no weight bearing for 6 weeks. Need to take a few days to deal with the logistics. My current apartment is upstairs, so I need to move and figure out a wheelchair and walkers, but I'll be back by next Tuesday if all goes well. I'm hoping you can delay my CBD bill.
So
There you
kind of
go.
awesome. Yeah. Chairman Zwanitzer.
Thank you, Mr. Speaker. Your committee number 10, Labor, Health, and Social Services, will meet tomorrow at 8 a.m. to hear the following 3 bills: House Bill 19, the State Indian Child Welfare Act Task Force; House Bill 66, prohibiting mask, vaccine, and testing discrimination; and House Bill 82, defendant mental illness examinations.
Chairman Washut.
Mr. Speaker, your committee number 1, Judiciary, will meet at 8 o'clock tomorrow morning in our normal meeting room to discuss 3 bills: House Bill 10, County Officers Bond Amounts; House Bill 15, County Authority to Dissolve Museum Boards; and House Bill 96, Transfer on Death Deed.
Chairman Nicholas.
Thank you, Mr. Speaker. Your Joint Appropriations Committee will meet 10 minutes after adjournment to do our final markup of the ARPA bill and the supplemental CAPCON bill. Then on noon tomorrow, your House Appropriations will do House Bill 51 and House Bill 2. And we will do re-referrals, House Bill 30, 109, and 181. And any others that we have time for, which could be 93.
You have heard the majority floor leader's motion. All those in favor say aye. Aye. Those opposed, no. Motion carries. The House is adjourned until 10 a.m. tomorrow, January 18th, 2023.